Oh, my jabby, jabby, defiant little minions. Let me help you out. We're going to help you out greatly. Don't want to promote what I'm consuming there, so forgive me. Office of the Attorney General, Washington, D.C., 20,530, October 6, 2017, memorandum for all executive and agencies. From the Attorney General, subject, federal law protections for religious liberty. The President has instructed me to issue guidance interpreting religious liberty protections in federal law as appropriate. Executive Order number 13798, subsection 4, 82 Federal Regulation 21675, May 4th, 2017, consistent with that instruction, I am issuing this memorandum and appendix to guide all administrative agencies and executive departments in the execution of federal law. Now, hold on for you guys out there. Memorandum, a short note written as a reminder, a written record or communication as in a business office, synonymous with letter, a short document outlining the terms of an agreement, especially a draft leading to a formal, detailed contract. Memorandum, all right? So for you guys out there that don't understand what memorandum is, again, it's my privilege and it's my pleasure to help you guys comprehend the language being used, all right? And thanks for entrusting in me to bring forward credible information to you and supporting selfgovernanceu.com, as well as all the classes that I promote and put out there. Okay, so again, the word memorandum, a short note written as a reminder, a written record or communication as in a business office, synonymous with letter, a short document outlining the term of an agreement, especially as a draft leading to a formal detailed contract, all right? So those are the definitions. And we're going to get started again. I'll just start from the top for those of you just joining. This came from the Department of Justice, Office of the Attorney General. It was gifted to me by Mr. Anonymous, Washington, D.C., 20,530, October 6, 2017, memorandum for all executive departments and agencies from the Attorney General, subject, federal law protections for religious liberty. Okay, for all of you jabby nuts out there that don't want to do the jabby walk of the zombie apocalypse, pay attention and listen up. Subject, federal laws protection for religious liberty. The President has instructed me to issue guidance interpreting religious liberty protections in federal law as appropriate. Executive Order number 13,798, subsection 4, 82 Federal Regulations 21,675, May 4th, 2017, consistent with that instruction, I am issuing the memorandum and appendix to guide all administrative agencies and executive departments in the execution of the federal law. Principles of religious liberty. Religious liberty is a foundation principle of enduring importance in America, enshrined in our Constitution and other sources of federal law. As James Madison explained in his memorial and remonstrance against religious assessments, the free exercise of religion is in its nature an unalienable right, because the duty owed to one's creator is precedent, both in order of time and in a degree of obligation, to the claim of civil society. Religious liberty is not merely a right to personal religious beliefs or even to worship in a sacred place. It also encompasses religious observance and practice. Except in the narrowest circumstances, no one should be forced to choose between living out his or her faith and complying with the law. Therefore, to the greatest extent practicable and permitted by law, religious observance and practice should be reasonably accommodated in all government activities, including employment, contracting, and programming. The following 20 principles should guide administrative agencies and executive departments in carrying out this task. These principles should be understood and interpreted in the light of the legal analysis set forth in the appendix to this memorandum. 1. Freedom of religion is a fundamental right of paramount importance expressly protected by federal law. Religious liberty is enshrined in the text of our Constitution and in numerous federal statutes. It encompasses the right of all Americans to exercise their religion freely without being coerced to join an established church or to satisfy a religious test as a qualification for public office. It also encompasses the right of all Americans to express their religious beliefs subject to the same narrow limits that apply to all forms of speech. In the United States, the free exercise of religion is not a mere policy preference to be traded against other policy preferences. It is a fundamental right. Now, let me draw your attention to something. You guys know how I'm always telling you they're not taking the proper oath? If you go look at the Article 6 oath, it does not mention anything about "so help me God." Why? Because religious requirements are not put in office, okay? So they're taking the Title V, 3331 oath of office, all right? And that's for profit, and it states, "so help me God," okay? It tells you right here that the religious test as a qualification for public office is not to be had, okay? So the "so help me God" falls underneath Title V, 3331, which means they're not taking the Article 6 oath, they're not taking the constitutional oath for the state, they're not taking the law of the flag oath under Title IV, 101, and they're not taking the state constitutional oath, all right? At least I have not found anybody that has, okay? James Madison Memorial on Remonstrance Against Religious Assessments, June 20th, 1785, and in 5 the Founders, Constitution 82, Philip B. Kurland and Ralph Lerner, ends, eds, edition, 1987. Federal Law Protections for Religious Liberty, page 2. Number 2, free exercise of religion includes the right to act or abstain from actions in accordance with one's religious beliefs. If you don't believe in the old jabby, if you don't believe in sticking foreign shit into your body, if you are religiously exempt, say it loud and say it proud and tell them to fuck off, all right? The Free Exercise Clause protects not just the right to believe or the right to worship, belief being the lack of knowledge, by the way. It protects the right to perform or abstain from performing certain physical activities in accordance with one's belief. Federal statutes, including the Religious Freedom Restoration Act of 1993, RFRA, support that protection. Broadly define the exercise of religion to encompass all aspects of observance and practice, whether or not central to or required by or particularly religious faith. All right, a particular religious faith. Let me tell you something. The First Amendment is the most important, or it wouldn't be number 1. The Second Amendment merely enforces the First Amendment. These amendments don't give you rights, don't coffer you rights. They merely draw the line in the sand for which these cretins are not supposed to cross. You remember that, and remember that well. Number 3. The freedom of religion extends to persons and organizations. Remember, God is not a respecter of persons, okay? So just substitute person with man in there and know who you are and the difference between person and man. The Free Exercise Clause protects not just persons, but persons collectively exercising their religion through churches or other religious denominations, religious organizations, schools, private associations, and even businesses. Number 4, Americans do not give up their freedom of religion by participating in the marketplace, partaking of the public square, or interacting with government. Constitutional protections for religious liberty are not conditioned upon the willingness of a religious person or organization to remain separate from civil society. Although the application of the relevant protection may differ in different contexts, individuals and organizations do not give up their religious liberty protections by providing or receiving social services, education, or health care, by seeking to earn or earning a living, by employing or to do the same, by receiving government grants or contracts, or by otherwise interacting with federal, state, and local government. Number 5, government may not restrict acts or abstentions, 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 because of the belief they display. To avoid the very sort of religious protections and intolerances that led to the founding of the United States, the Free Exercise Clause of the Constitution protects against government actions that targets religious conduct. Except in rare circumstances, government may not treat the same conduct as lawful when undertaken for secular reasons, but unlawful when undertaken for religious reasons. For example, government may not attempt to target religious persons or conduct by allowing the distribution of political leaflets in a park, but forbidding a distribution of religious leaflets in the same park. Number 6, government may not target religious individuals or entities for specific disabilities based on their religion, much as government may not restrict actions only because of religious beliefs. Government may not target persons or individuals because of their religion. Government may not exclude religious organizations as such from secular aid programs, at least when the aid is not being used for explicitly religious activities such as worship or proselytization. Proselytization. For example, the Supreme Court has held that if government provides reimbursement for scrap tires to replace child playground surfaces, it may not deny participants in that program to religious schools. Nor may federal law protections for religious liberty. Page 3. Government deny religious schools, including schools whose curricula and activities include religious elements, the right to practice in a voucher program so long as the aid reaches the schools through independent decisions of parents. Number 7, government. Government may not target religious individuals or entities through discriminatory enforcement of neutral, generally applicable laws. Although government generally may subject religious persons and organizations to neutral, generally applicable laws, ergo across-the-board criminal prohibitions, or certain time, place, and manner restrictions on speech, government may not apply such laws in a discriminatory way. For instance, the Internal Revenue Service may not enforce Johnson Amendment, which prohibits 501c3 nonprofit organizations from intervening in a political campaign on behalf of a candidate against a religious nonprofit organization under circumstances in which it would not enforce the amendment against a secular nonprofit organization. Likewise, the National Park Service may not require religious groups to obtain permit to hand out flyers in a park if it does not require similarly situated secular groups to do so as well. And no federal agency tasked with issuing permits for land use may deny a permit to an Islamic center seeking to build a mosque when the agency has granted or would grant a permit to similarly situated secular organizations or religious groups. 8. Government may not officially favor or disfavor particular religious groups. Together, the Free Exercise Clause and the Establishment Clause prohibit government from officially preferring one religious group to another. This principle of denominational neutrality means, for example, the government cannot selectively impose regulatory burdens on some denominations but not to others. It likewise cannot favor some religious groups for participation in the combined federal campaign over others based on the group's religious beliefs. 9. Government may not interfere with the autonomy of a religious organization. Together, the Free Exercise Clause and the Establishment Clause also restrict governmental interference in intra-denominational disputes about doctrine, discipline, or qualifications for ministry or membership. For example, government may not impose its non-discrimination rules to require Catholic seminars or Orthodox Jews, yeshivas, to accept female priests or rabbis. Number 10, the Religious Freedom Restoration Act of 1993 prohibits the federal government from substantially burdening any aspect of religious observance or practice unless imposition of that burden on a particular religious adherent satisfies strict scrutiny. RFRA prohibits the federal government from substantially burdening a person's exercise of religion unless the federal government demonstrates that application of such burden to the religious adherent is the least restrictive means of achieving a compelling governmental interest. RFRA applies to all actions by federal administrative agencies, including rulemaking, adjudication, or other enforcement actions, and grant or contract distribution and administration. Federal law protections for religious liberty, page 4. Number 11, RFRA protections extend not just to individuals, but also organizations, associations, and at least some for-profit corporations. RFRA protects the exercise of religion by individuals and by corporations, companies, associations, firms, partnerships, society, and joint stock companies. For example, the Supreme Court has held that Hobby Lobby, a closely held for-profit corporation with more than 500 stores and 13,000 employees, is protected by RFRA. 12. RFRA does not permit the federal government to second-guess the reasonableness of a religious belief. RFRA applies to all sincerely held religious beliefs, whether or not central to or mandated by a particular religious organization or tradition. Religious adherent will often be required to draw lines in the application of their religious beliefs, and government is not competent to assess the reasonableness of such lines drawn, nor would it be appropriate for government to do so. Thus, for example, a government agency may not second-guess the determination of the factory workers that, consistent with his religious precepts, he can work on a line production steel that might someday make its way into armaments, but cannot work on a line producing the armaments themselves. Nor may the Department of Health and Human Services second guess the determination of a religious employer that provides contraceptive coverage to its employees would make the employer complicit in wrongdoing in violation of the organization religious precepts. Number 13, a governmental action substantially burdens an exercise of religion under the RFRA if it bans and expects of an adherent's religious observance or practice, compels an act inconsistent with that observance or practice, or substantially pursues the adherent to modify such observance or practice. Because the government cannot second-guess the reasonableness of a religious belief or the adherent's assessment of the religious connection between the government mandate and the underlying religious belief, the substantial burden test focuses on the extent of the government compulsion involved. In general, a government action that bans an aspect of an adherent's religious observance and practice, compels an act inconsistent with the observance or practice, or substantially pressures the adherent to modify such observance or practice, will qualify as a substantial burden on the exercise of religion. For example, a Bureau of Prison Regulations that bans a devout Muslim from growing even a half-inch beard in accordance with his religious beliefs substantially burdens his religious practice. Likewise, a Department of Health and Human Services regulation requiring employees to provide insurance coverage for contraceptive drug in violation of their religious beliefs or face significant fines substantially burdens their religious practice, and a law that conditions receipt of significant government benefits on willingness to work on Saturday substantially burdens the religious practice of those who, as a matter of religious observance and practice, do not work on that day, but a law that infringes even severally an aspect of an adherent's religious observance or practice that the adherent himself regards as unimportant or inconsequential, imposes no substantial burden on the adherent, and a law that regulates only the government and government's internal affairs and does not involve any governmental compulsion on the religious adherent likewise imposes no substantial burden. Federal law protections for religious liberty, page 5. Number 14, the strict scrutiny standard applicable to the RFRA is exceptionally demanding. Once a religious adherent has identified a substantial burden on his or her religious beliefs, the federal government can impose that burden on the adherent only if it is the least restrictive means of achieving a compelling governmental interest. Only those interests of the highest order can outweigh legitimate claims to a free exercise of religion. And such interest must be evaluated not in broad generalities, but as applied to the particular adherent. Even if the federal government could show the necessary interest, it would also have to show that its chosen restrictions on free exercise in the least restrictive means of achieving that interest. That analysts require the government to show that it cannot accommodate the religious adherent while achieving its interest through a viable alternative, which may include, in certain circumstances, expenditure of additional funds, modification of existing exemptions, or creation of a new program. Number 15, RFRA. Again, this is about the old jabby. And if they're saying, well, look, I'm just going to sit here and tell you how it is right now. We're going to let you know that, this is mandatory because there's an international whatever going on, crisis. Make them prove that they have isolated CoV-SARS-2. Make them prove that they have isolated it. Title 15 RFRA applies even where a religious adherent seeks an exemption from a legal obligation requiring the adherent to confer benefits on a third party. Although burdens imposed on third parties are relevant to the RFRA analysts, the facts that an exemption would deprive a third party of a benefit does not categorically render an exemption unavailable. Once an adherent identifies a substantial burden on his or her religious exercise, RFRA requires the federal government to establish that denial of the accommodation or exemption to that adherence is the least restrictive means of achieving a compelling governmental interest. Number 16, Title VII of the Civil Rights Act of 1964, as amended, prohibits covered employers from discriminating against individuals on the basis of their religion. Employees covered by Title VII may not fail or refuse to hire, discharge, or discriminate against any individuals with respect to compensation, terms, conditions, or privileges of employment because of that individual's religion. Such employers also may not classify their employees or applicants in a way that would deprive or tend to deprive any individual of employment opportunities because of their individual's religion. This protection applies regardless of whether the individual is a member of a religious majority or minority, but the protection does not apply in the same way to religious employers who have certain constitutional and statutory protections for religious hiring decisions. Number 17, Title VII protection extends to discrimination on the basis of religious observance or practices as well as a belief. Unless the employer cannot reasonably accommodate such observance or practice without undue hardship on the business, Title VII defines religion broadly to include all aspects of religious observance or practice except when an employer can establish that a particular aspect of such observance or practice cannot reasonably be accommodated without undue hardship to the business. For example, covered employers are required to adjust employee work schedules for Sabbath observance, religious holidays, and other religious observance unless doing so would create an undue hardship, such as materially compromising operations or violating a collective bargaining agreement. Title VII might also require an employer to modify a no-head covering policy to allow a Jewish employee to wear a yarmulke or a Muslim employee to wear a headscarf, and federal law protections for religious liberty, page 6. Employer who contends that it can't not reasonably accommodate a religious observance or practice must establish undue hardship on its business with specificity. It cannot rely on assumption about hardship that might result from an accommodation. Number 18, the Clinton guidelines on religious exercise and religious expression in the federal workplace provide useful examples for private employers of reasonable accommodations for religious observance and practice in the workplace. President Clinton issued, and these people are just disgusting. I hate even reading this any further at this point. President Clinton issued guidelines on religious exercise and religious expressions in the federal workplace. Clinton guidelines explaining that the federal employees may keep religious materials on their private desk and read them during breaks, discuss their religious views with other employees, subject to the same limitations as other forms of employee expressions, display religious messages on clothing or wear religious medallions, and invite others to attend worship service at their churches, except to the extent that such speech becomes excessive or harassing. The Clinton's guidelines have the force of an executive order, and they also provide useful guidance to provide employers about ways in which religious observance and practice can reasonably be accommodated in the workplace. Number 19, religious employers are entitled to employ only persons whose beliefs and conduct are consistent with the employer's religious aspects. Constitutional and statutory protections apply to certain religious hiring decisions. Religious corporations, associations, educational institutions, and societies, that is, entities that are organized for religious purposes and engaged in activity consistent with and in furtherance of such purposes, have an express statutory exemption from Title VII prohibition on religious discrimination in employment. Under that exemption, religious organizations may choose to employ only persons whose belief and conduct are consistent with the organization's religious precepts. For example, the Lutheran Secondary School may choose to employ only participants consistent with the precepts of the Lutheran community sponsoring the school. Indeed, even in the absence of the Title IV exemption, religious employers might be able to claim a similar right under the RFRA or the religion clause of the Constitution. Number 20, as a general matter, the federal government may not condition receipt of a federal grant or contract on the effective relinquishment of a religious organization hiring exemption or attributes of its religious charter. Religious organizations are entitled to compete on equal footing for the federal financial assistance used to support government programs. Such organizations generally may not be required to alter their religious character to participate in a government program, nor to cease engaging in explicitly religious activity outside the program, nor effectively to relinquish their federal statutory protections for the religious hiring decisions. This is federal law protections for religious liberty. All right. So I hope that helps you guys out with the old jabby thing. And I got to really stop making these videos about the old jabby because it's going to get me in trouble. But again, if you want to look up what I just read to you, this is from the Department of Justice. It's the Office of the Attorney General, Washington, D.C., 20,530, October 6, 2017. It's a memorandum for all executive departments and agencies from the Attorney General, subject federal law protection for religious liberties. Go look it up. If you're having problems with the school, you're having problems with the county boards, you're having problems, bring this to their attention and smack them in the face with it. Thank you.